We welcome in our first guest, and that is Paul Callan, CNN legal analyst. Hello, Paul.
Good. How are you doing today, Steve? Always good to talk to you.
Always good to talk to you. Okay, so let's start with the Arizona law, if we could. Were you? I mean, I don't think many people were surprised that Jan Brewer wound up vetoing the bill.
Well, I wasn't surprised ultimately because I think from a business, she's a Republican, and I think from a business standpoint, they had made a determination that this is going to kill Arizona. I mean, conventions left and right were canceling already. So I think it was in part an economic judgment and pressure from the business community. I don't even think it had to do with some of the other issues that have been so widely discussed.
Okay, now let's talk about the law a little bit. I know you've talked about it on CNN. If that law was, if that bill had been signed into law by the governor, would it ever have seen the light of day? I mean, would it be a day or less before someone went to court and got a challenge to it, and a judge issued a stay?
Well, no, I don't think that it would have been a day or two before it wound up in court. I think that you would have had a situation where somebody got sued for discriminating, let's say, against a same-sex couple, and they invoked the defense of the Arizona Religious Freedom Restoration Act. It would be at that point that the courts would get involved in the situation, and it might take a few months or before that would happen. And I think eventually it would have wound up in federal court, and you know, it would have been a major case because, by the way, Steve, there are a lot of these laws in other parts of the country already on the books about religious freedom, and there's this balancing test, very difficult test for the courts, because, you know, the First Amendment says you have the right to practice religion and not have the government interfere in that right. But on the other hand, ever since this right of privacy was recognized by the Supreme Court in a case called the Griswold case, the two rights sort of, you know, crash into each other from time to time, especially with respect to same-sex marriage. So.
All right. Well, it's funny you said same-sex marriage. Let's go there, and let's talk about what happened in Texas yesterday with the judge, a federal judge, declaring that a same-sex marriage ban, which is in the Constitution of the state of Texas, and it's also in a law in the state of Texas, and he said that it's unconstitutional, but he will allow the state to enforce the law pending an appeal that will likely go all the way to the Supreme Court. So first talk about what he did, and then where you think this will eventually all be settled.
Well, here's why I think the case is very, very interesting. First of all, Texas voters enacted a law, and it eventually had the force of a Texas constitutional amendment, saying basically that marriage would be defined as between one man and one woman. That's it. So same-sex marriage would not be recognized by Texas, and this was overwhelmingly adopted by Florida voters. And as a result of that law, a lesbian couple traveled to Boston. They got married. They came back to Texas, and they're the ones who started this lawsuit that winds up in front of this federal judge, Garcia. Now, Garcia, looking at the case, says, well, there's been a history now, and there was a case, remember, in California where their constitutional amendment banning gay marriage was struck down. And he looked at those precedents and said, essentially, under the 14th Amendment, the Equal Protection Clause of the United States Constitution, the government is permitted to treat people differently. For instance, obviously, women can be treated differently than men in certain circumstances. I mean, it used to be they weren't in combat, and you know, but I suppose the clearest thing is you're allowed to have a ladies' room and a men's room. That's perfectly legal. They're not being treated the same. They're being treated differently, but you have to have a good reason if you're going to do that. And the lawyers call it a compelling state interest or a rational basis. But there's got to be a good reason. I'll give you another example. Let's say a prisoner is trying to express his free speech under the First Amendment, and he starts denouncing the warden of the state prison. Well, he's going to wind up in solitary confinement, and that's perfectly legal. He doesn't have the same First Amendment right as everybody else. The law allows that because he's got himself in jail. So there's a compelling state interest to treat prisoners differently. So now we get to this case. And this judge says, you know, you have to prove to me that there's a compelling state interest or a rational basis or a solid reason why the government treats gays differently than heterosexual couples. And I don't see that reason being proven. And he then threw out the constitutional amendment to the Texas law and essentially legalized gay marriage in Texas, and said also, by the way, that Texas has to recognize out-of-state gay marriages. So, but he stayed the decision pending an appeal to a higher court, the Fifth Circuit, which is in New Orleans and covers a number of southern states.
Right, and so that's where the next ruling will come. But what he said also, he said, without a rational relation to a legitimate governmental purpose, state-imposed inequality can find no refuge in our United States Constitution. Now, this goes above and beyond what the U.S. Supreme Court said in their recent decisions on gay marriage. Does it not?
Yes, it does. You know, the court in its recent decision was very careful and very narrow in the rulings that it handed down. But what's being set up here is when the circuits, you know, the way the feds have the court system set up is there are circuit appellate courts that cover large segments of the United States. And when, let's say, the California circuit is at odds with the circuit that covers Texas, we have different parts of the United States being governed by essentially different laws. And when there's a conflict in the circuits, it's at that point that the Supreme Court says, well, we're going to step in and resolve it once and for all. And a lot of times the court does what it did in this case, what it's been doing with respect to same-sex marriage. It takes tiny steps to see what the lower courts are going to do, to let it percolate up, to let public opinion formulate one way or another. But I think we're going to see a big Supreme Court decision come down on this eventually. And yes, he clearly went well beyond what the Supreme Court has ruled so far in this area. And the other thing, I find it to be such a fascinating topic. It's all about judge-made law versus democratically made law. You know, all of these laws are being thrown out by individual judges, and Texas majority of voters voted in favor.
Well,
so
you're reading my mind, yeah, Paul. Because well, go ahead, say what you're going to say. Because my next question to you was, what happens to state rights? What happens to the right of a state to vote something into their constitution and to have it stay there? I mean, is every time now that a referendum comes to before the people, I mean, I guess this has always been the case, but it's more likely now than ever to be overturned by a judge?
Well, there has certainly been this trend in recent years, and the interesting thing is when I look at a lot of these decisions that have been handed down with respect to the same-sex marriage thing, which is very, very important to a lot of people of a lot of different religions because of, religious belief that opposes homosexuality, they tend to quote these federal judges or state judges as well who go in favor of same-sex marriage. You know who they quote? Scalia, all right? Because Scalia, by the way, wrote a very famous defense in the case of Lawrence versus Texas, of all places, in which the Supreme Court struck down a criminal law against sodomy in Texas. I gotta go. In that law, Scalia issued a scathing dissent, basically saying that if you do this, then laws against bigamy, laws against all kinds of other acts will never be upheld in the future. And of course, at least with respect to homosexual marriage and gay marriage, Scalia is proving to be correct. Yeah, so. and
one other thing, I know there's no way on the face of the earth to venture a prediction, but based on the fact that the court has taken on 2 decisions on this issue in the recent past, just a few months ago, when they get a case of maybe this judge, let's say, who said what he said here about the U.S. Constitution, based on how they've ruled already, what do you think they might do if this case comes before them?
Well, I think the court, as it's currently composed, is probably going to rule in favor, eventually, of same-sex marriage, and they'll do it. They're never going to issue a rule saying every state must recognize same-sex marriage, but what they're going to say is that the 14th Amendment to the Constitution applies, and that if a state is going to ban it, it has to have a rational basis or a compelling state interest in doing so. And traditionally, Steve, that had to do with the basis that was used was that same-sex couples couldn't raise kids the same way, and that there was a cultural history of not only of the United States but of Western civilization where same-sex marriage was not recognized, and traditionally the courts could recognize cultural traditions in the United States. But that seems to have been thrown out by modern trends now. I don't think a cultural tradition is going to be recognized by the court, and frankly, I don't think statistically you'll be able to come up with studies that scientifically demonstrate that heterosexual couples are better than homosexual
I think
couples.
I think it's common sense that a mother and a father are the best thing in the world for kids, and I don't think that it's been around long enough to have, you need decades and decades and generations of studies before you could say, oh no, the kids are just as well off with the alternative than the tradition. I mean, how do we know that? What, based on a few years of
you know, you're talking common sense.
Right.
I'm talking courts of law. Sometimes there's a major difference there, Steve. And, you know, your view of common sense is obviously very different from the common sense that may be out there in the gay community.
All right, listen, I appreciate it, Paul. Always great to talk to you. Paul Callan, CNN legal analyst on the Steve Malzberg Show.
The Steve